So today is 5th March, Tuesday, 2024. So on the Indian Express explained page, there is an important article when lawmakers takes bribe. So Supreme Court has overturned the 26-year-old verdict in the JMM bribery case. So what did it rule and how this case is related to the bribery? So this is the crux of this article. So let us see. The article is divided into two parts. First is how top court interpreted the privileges of legislators. So let us see what is it says. A seven-judge constitutional bench of the Supreme Court, headed by Chief Justice of India D.Y. Chandrachud, ruled that lawmakers facing bribery charges in connection with their speech and votes in the House cannot be immune from criminal prosecutions. In doing so, the court held that claims to parliamentary privilege by lawmakers can be subject to judicial review, and only Parliament cannot have the last word on the issue. Apart from CJI Chandrachud, Justice A.S. Bopanna, M.M. Sundaresh, and P.M. Narasimha, J.B. Padriwala, Sanjay Kumar, and Manoj Misra were part of the bench. So the constitutional bench should comprise minimum of five judges. So what does the law says and what top court had to decide? So Article 105 Clause 2 of the Constitution states no member of the parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the parliament or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of a house of parliament of any report, paper, votes or proceeding. So this is related to parliament, and the same concept is also provided to the state assemblies under Article 194 Clause 2 that provides identical protection to members of the state assemblies. So before the seven judge bench was established, essentially the interpretation of this provision was previously interpreted in the 1998 JMM bribery ruling. So the correctness of that ruling had to be tested. So interpreting the law on the privileges of MPs and MLAs. So, tracing the history of parliamentary privileges in India, the Supreme Court said that unlike the House of Commons in the UK, India does not have an ancient and undoubted rights vested after the struggle between Parliament and the King. These rights in India, even during colonial times, have flown from a statute, which after independence transitioned to a constitutional privilege. This the court cited as a reason to interpret privilege in a way that fits with the larger ideal of the constitution. There are two opponents of parliamentary privilege. One is what the House exercises collectively, which would include the power to punish for its contempt, the power to conduct its own affairs, among others. The second is for individual rights, say exercise of free speech by each member. This, the court said, has to pass a test. The ruling cited the necessary test, which means that for a member to exercise a privilege, the privilege must be such that without it, they could not discharge their functions. Naturally, accepting bribes cannot be said to be necessary to discharge one's functions as a lawmaker, unlike, for example, having the right to free speech. The court also said that the Constitution envisions probity in public life. Corruption and bribery of members of the legislature erode the foundation of the Indian parliamentary democracy. It is destructive of the aspirational and deliberative ideals of the Constitution and creates a polity which deprives citizens of a responsible, responsive, and representative democracy, the ruling stated. So, a corrupt vote or a vote of conscience by MPs. The court also had to decide if a lawmaker gets immunity if he accepts a bribe but votes as per his conscience or party line and not as per the request of the bribe giver. Essentially, without a quid pro quo, can accepting money shall be quitted to graft. The court analyzed section 7 of the Prevention of Corruption Act, which deals with offense relating to public servant being bribed. The mayor obtaining, accepting, or attempting to obtain an undue advantage with the intention to act or forbear from acting in a certain way is sufficient to complete the offense. it is not necessary that the act for which the bribe given be actually performed. Okay. So it is not necessary that the act for which the bribe is given be actually performed, the court said. That means only taking bribe will be wrong as per the court. This means that accepting a bribe is an offense as is, and it does not depend on the whether the public servant acted differently. The court also said that it would be a violation of the right to equality under Article 14 of the Constitution to create an illegitimate class of public servants which is afforded extraordinary protection. Such a classification, the court said, would be manifestly arbitrary. So, can court punish elected representatives? Since Parliament has the power to punish its member for contempt, the punishment here could be suspension from the House and even sentencing to jail term. The Supreme Court had to decide whether this meant court had no role to play. The Supreme Court held that both the court and Parliament can exercise jurisdiction on the actions of lawmakers in parallel. This is because the purpose of punishment by the House is different from the purpose of a criminal trial. The issue of bribery is not one of the exclusivity of jurisdiction by the House over its bribe taking members. The purpose of a House acting against a contempt by a member for receiving a bribe serves a purpose distinct from a criminal prosecution, the court said. Okay. So this was the article. There is another half article, but we'll stop today here only.